Salalima v Ginguna 257 SCRA 55. Facts: this refers to the administrative complaint filed against Albay Governor Romeo Salalima, Vice Governor Danilo Azafla, Albay Sangguniang Panlalawigan members Juan Victoria, Lorenzo Rieg, Jesus Mark Elana, Arturo Ozia, Clinio Cabarido, Ramon Fernandez, Jr., Masacap Fontanilla, Vicente Go, Sr., and Nemesio Baclao relative to the retainer contract for legal services entered into between the province of Albay, on the one hand, and attorney Jesus R. Cornigo and the Cortez and Reyna law firm, on the other, and the disbursement of public fund in payment thereof. The complaint alleges that by entering into the retainer agreement with private lawyers and paying P7, 380, 410, 31 to the said private lawyers, respondents violated several provisions of law which warrants the imposition of administrative penalties against them. It is to be noted that respondents Victoria, Rieg, Cabarido, Mark Elana, and Ozia were not yet members of the Sangguniang Panlalawigan when Resolution Number 129 was passed. However, the complaint alleges that these respondents were named in the complaint because they approved the supplemental budget/appropriation ordinances providing for the payment of the attorney's fees. Issue 1. Respondents have incurred administrative liability in entering into the retainer agreement with attorney Cornigo and the Cortez and Reyna law firm and in making payments pursuant to said agreement for purposes of the case filed by NPC with the Supreme Court against the province. Held yes ratio, Sector 481 of the Local Government Code, RA No. 7160, requires the appointment of a legal officer for the province whose functions include the following: represent the local government unit in all civil actions and special proceedings wherein the local government unit or any official thereof, in his official capacity, is a party, provided that, in actions or proceeding where a component city or municipality is a party adverse to the provincial government or to another component city or municipality, a special legal officer may be employed to represent the adverse party. The Supreme Court has ruled in Municipality of Baco, ETLV Manatok, that local government units cannot be represented by private lawyers and it is solely the provincial fiscal who can rightfully represent them. This ruling applies squarely to the case at hand because Sections 481 of the Local Government Code is based on Sector 1681 of the Revised Administrative Code, which was the subject of interpretation in the case of Municipality of Baco, ETLV Manatok. In hiring private lawyers to represent the province of Albay, respondents exceeded their authority and violated the above-quoted section of the Local Government Code and the doctrine laid down by the Supreme Court. Moreover, the entire transaction was attended by irregularities. First, the disbursements to the lawyers amounting to P7,380,410. 31 were disallowed by the provincial auditor on the ground that these were made without the prior written conformity of the Solicitor General and the written concurrence of the Commission on Audit, as required by COA Circular No. 86-25-5 dated April 2, 1986. The respondents attempted to dispute this finding by presenting the Solicitor General's conformity dated July 15, 1993. This conformity was, however, obtained after the disbursements were already made in 1990 and 1992. What is required by COA Circular No. 86-255 is a prior written conformity and acquiescence of the Solicitor General. Another irregularity in the transaction concerns the lawyers. Resolution number 01-90 authorized the respondent governor to sign and confirm a retainer contract for legal services with the Cortez and Reyna law firm at 202 East Rodriguez Sr. Boulevard, Quezon City. The retainer contract signed by respondent governor was, however, not only with the Cortez and Reyna law firm but also with attorney Jesus R. Cornigo of Jamaica Building, 280 Tomas Morato Avenue, Quezon City. That attorney, Jesus R. Cornigo, and the Cortez and Reyna law firm are two separate entities, is evident from the retained contract itself. In entering into a retainer agreement not only with the Cortez and Reyna law firm but also with attorney Jose R. Cornejo, respondent governor exceeded his authority under Resolution No. 01-90. Complicating further the web of deception surrounding the transaction is the fact that it was only attorney Cornejo who appeared as collaborating counsel of record of the province in the Supreme Court case. Even the Solicitor General, in his letter to respondent governor dated July 15, 1993, noted that the province is represented in the Supreme Court by Addis, Ricafort Cornejo and Glenn Manahan but not by the Cortez and Reyna law firm. Furthermore, the memorandum with the Supreme Court filed for the province was signed by attorney Cornejo and not by the Cortez and Reyna law firm. Consequently, the Cortez and Reyna law firm was not counsel of record of the province in GR number 87,479. And yet, 6 of the 10 checks paid by the province and amounting to more than P3.6 million were issued in favor of the Cortez and Reyna law firm through attorney Antonio Jose Cortez. In other words, respondents disbursed money to the Cortez and Reyna law firm although the latter did not appear as counsel for the province in the Supreme Court in GR number 87,479. Finally, the attorney's fees agreed upon by respondent Salalima and confirmed by the other respondents are not only unreasonable but also unconscionable. The contingent fee of 18% of the P2L4 million claim of the province against NPC amounts to P38.5 million. The word unconscionable, as applied to attorney's fee, means nothing more than that the fee contracted for, standing alone and unexplained would be sufficient to show that an unfair advantage had been taken of the client, or that illegal fraud had been taken of the client, or that illegal fraud had been perpetrated on him. The province has a legal officer, attorney Ricafort, who had already filed a comment on NPC's petition against the province. The comment filed by attorney Ricafort already covers the basic issues raised in the petition. When attorney Cornejo filed an appearance and subsequently a memorandum for the province, the petition was already been given due course by the Supreme Court and the only pleading to be filed by the parties before the court would issue its decision was a memorandum. Surely, one memorandum could not be worth P38.5 million. Furthermore, the professional character and social standing of attorney Cornejo are not such as would merit a P38.5 million fee for the legal services rendered for the province. During the hearing, respondent governor admitted that he had hired attorney Cornejo because they were schoolmates at San Beda College. It is evident that respondent governor hired attorney Cornejo not on the basis of his competency and standing in the legal community but purely for personal reasons. Likewise, the standing of the Cortez and Reyna law firm is not such as would merit P38.5 million for one memorandum, which, in this case, it had not even filed because it was not the counsel of record. Hence, considering the labor and time involved, the skill and experience called for in the performance of the services and the professional character and social standing of the lawyers, the attorney's fee of P38.5 million is unconscionable. By allowing such scandalously exorbitant attorney's fees which is patently disadvantageous to the government, respondents betrayed a personal bias to the lawyers involved and committed abuse of authority.